Greetings to all the viewers of SNIPit3 live conference. My name is Lucas Marques, and I would like to welcome you today for an interesting chat covering the topic of maritime casualties, investigations, and liabilities. The purpose of this conference is to bring you a very brief idea on how a sensitive maritime incident can be handled in different jurisdictions around the globe, starting with a quick view from an Asian perspective delivered by the brilliant Fuzet Farid, covering Malaysia and Singapore jurisdictions. Then we will touch base with our expert from Africa, Tunji Adeyemi, who will bring some insights from Nigeria. And we will conclude our trip around the globe in South America with our star from Argentina, Belen. In order to provoke our speakers of the day, I would like to address here a hypothetical scenario, and that will be the lead for today's conference. But before doing that, I would like to welcome our viewers that are following us live to address any eventual questions in the chat, as we may cover those in a final Q&A in the end if the time allows. So the facts of our case study for the day are the following. Imagine that a certain maritime carrier, which is a foreign entity if compared to your jurisdiction, was hired by a multinational trading company for the carriage of 300,000 metric tons of iron ore from abroad with destination to your country. The cargo was shipped with some delay at the loading port and was carried on board a foreign flag vessel to your jurisdiction. In the final moments of the ocean voyage, while entering the discharge port in your country with the pilot on board, a sudden heavy storm with strong winds and big swells hit the area. Opposing the pilot's advice to abort the maneuver, the master of the vessel decided to proceed with the berthing operation, alleging that the vessel had already suffered previous delays and owners were under severe commercial pressure. During the maneuver, the vessel lost control and ended up colliding with an oil tanker berthed at port. As a result of such incident, the vessel ended up taking water and grounding in the port canal. The tanker also suffered considerable damages, causing a spill at port and also hit terminal structures. I understand that this is a tragic scenario, and thankfully it is just hypothetical, but it's important to be prepared, and SNIPit3 audience will be very much interested in hearing from our experts. So let me start in Asia with Fuzet. Fuzet, I know so far we only have limited information, which is often the case when the matter first arrives, but in a scenario like this, what would be the first thing you would do when the owner or the master or the club gives you a call?
Hi, Lucas. It's great to be on this SNIPit3 session with you, Tunji and Maria. Jumping straight in, my answer to the first question, what's the first thing you do when the master or the club calls, is the first priority is to collect as much information as quickly as possible from the master. This allows us to confirm the P&I cover and to determine whether I have the authority to act on their behalf. The information I typically ask for includes the name of the vessel, the owner, the charterer, the P&I club, the vessel's position, the extent of damage and any pollution risks, the port of registry, the time and angle of the collision. Once I have this information, I notify the company's designated person ashore, DPA, and identify the vessel's agents so that we can coordinate and activate the vessel's response plan. This is critical because we need to deal with all jurisdictions that may be affected by the collision. For example, in my practice, Singaporean and Malaysian waters are adjacent to each other. A collision in this region may impact both jurisdictions, so we must treat it as such. This means notifying the company's DPAs in both Singapore and Malaysia. Similarly, when notifying government authorities, including the flag state, the port state, and coastal state, we must notify both Singaporean and Malaysian authorities. In Malaysia, the first point of contact is the Malaysian Marine Department, MMD. The MMD, or the nearest harbour master, must be informed of a collision within 24 hours. The report must be transmitted in writing, signed by the ship owner or the master, and must state the name of the ship, its official number, its port of registry, and its exact location. The master must also make a statement in the ship's logbook describing the circumstances of the collision. The MMD will then coordinate any rescue efforts with the Malaysian Maritime Enforcement Agency, or MMEA, which is Malaysia's equivalent of a Coast Guard. In Singapore, by contrast, the relevant authorities are the Maritime and Port Authority of Singapore, MPA, and the Transport Safety Investigation Bureau, TSIB. Both must be notified within 2 hours of the incident, whether by email or via their 24-hour hotlines. The MPA has a comprehensive list of email addresses to notify, including Flag State Control, Ship Registry, Maritime Investigation Department, Seafarers Policy Development and Welfare, and Port Marine Safety. A detailed report needs to be submitted to the MPA within 24 hours and to the TSIB within 7 days. That's probably all I can cover for now. Tunji, as the next speaker, will address lining up expert witnesses, issuing press releases, and conducting the legal assessment of potential liabilities, including the limits of liability.
Indeed, Fuzet. Many thanks for these initial insights from a Southeast Asian perspective. Now, if this incident had occurred in a port in Nigeria, Tunji, what would be your biggest initial concerns in such a case?
Thank you, Lucas, and thank you, Fuzet. So getting straight to it, I think the first priority obviously will be preservation of life. The scenario you painted, potentially there could be harm to the relevant people involved. So we don't take for granted that the relevant authorities are aware of the incident. Formal reports will be made to the Nigerian Port Authority, the Nigerian Maritime Education and Safety Agency, and also the Oil Spill Detection and Response Agency. These three agencies working with the Marine Police and the Nigerian Navy typically would undertake rescue operations and prevent any further damage to life and property. We would also contact the Office of the Receiver of Wrecks in Nigeria, which is a designated office responsible for designating certain wrecks as hazard. Where the Receiver of Wrecks determines that the wreck constitutes a hazard, that information will be promptly passed on to the ship owner. Usually the ship owner would contract a third-party salvor with local expertise to help the wreck removal, just so that there's no further harm and damage caused to other persons and vessels involved. In relation to public announcements and press releases, in Nigeria, typically this will be done by some of the agencies that I mentioned previously. And typically you would see that done within the first 24 to 48 hours of the incident. The concern, though, with these press releases is you don't want the public opinion already being shaped in terms of culpability of your clients, right? And if the matter is not in court within that short period, it will be helpful to also put out your press release that clarifies the position of your client. In terms of other initial concerns, clearly gathering information is key, as Fuzet said. And we would typically push for the appointment of a marine surveyor as quickly as possible. As you know, a marine surveyor will be responsible for carrying out an initial assessment of the incident, the vessels involved, equipment involved, and then he would come up with his report. Okay, we would also make effort to contact the captain, the pilot involved in the scenario that you mentioned, and other eyewitness account. All of this would review the incident, and typically the marine surveyor will issue a report. Now, it's typically the case that when this report is issued and it's passed on to the ship owners of the P&I Club, they will want to assess the culpability of their client, right? And so usually we would probably be required to issue a legal opinion on the scope of their liability or otherwise. I guess the last initial concern that I need to address is in terms of criminal liability, okay, and ensuring that the liberty of the captain and those involved is preserved. And the reason for this is because the breach of safety regulations in Nigeria constitutes a criminal offense. And so it's not out of place that in this scenario that you mentioned, the captain and maybe other crew members might be arrested by the Marine Police So it's very, very critical that as lawyers involved, we ensure that the liberty of the captain and all other crew members involved is preserved. If indeed they are arrested and detained, we will push to ensure that they get bail as soon as possible. If that is refused, then we'll then approach the court to ensure that we get bail. So these are the initial concerns that I'll typically have if this scenario were to play out in Nigeria.
Thank you, Tunji. Those are indeed some critical points of concern, and many thanks for addressing them. There are quite many, right, in an incident like that. But now I'm happy to say to you, Tunji, that this event did not happen in Nigeria, but rather in a port in Argentina, Maria Belen. Normally on a Friday evening, when you're contacted by the owner and the club asking what sort of investigations would you expect to happen in this case, what type of claims, what type of liabilities could arise. So Maria Belen, please, the floor is yours.
Thank you very much, Lucas. Thank you for this opportunity to be here as part of this SNIPit3 session. Going straight to my question, which kinds of investigations can be expected to happen? Well, this will depend on the different liabilities and the different kind of liabilities that may arise from an incident of this magnitude. For example, we will have administrative investigations. In Argentina, they are carried out by the Maritime Authority, which is the Prefectura Naval. They will assess the conduct of the persons that have been involved, mainly the conduct of the master, of the pilot. Sometimes they also assess the conduct of the ship owner as well. And they will basically analyze if they have committed infringements to the administrative rules. Those related with navigation issues, safety of navigation issues, or environmental protection issues, which in Argentina are contained in an administrative regime called Reginave. If the liability is imposed, the sanctions that could arise in this forum usually range from fines or suspension or revocation of the license of the crew which have been involved, or suspension of revocation of the ability to operate of the ship owner. Then, if the incident also gave rise to criminal consequences, the criminal proceedings will be also started, and these in Argentina are carried out by criminal courts. Criminal court will analyze if the conduct of the parties involved are punishable under criminal laws. So in cases as the one under analysis, criminal offenses that could happen could be those related with shipwrecks, homicide, environmental pollution, and if liability is considered that arose, the liable parties will be sanctioned with criminal sanctions, which in this case, they are related with imprisonment or jail. The evidence that is gathered in the administrative proceedings and in the criminal proceedings are very relevant for the distribution and apportionment of the civil liability, but they are not binding nor decisive. And then the third kind of investigations that will be pursued are those related with the determination of the civil liability involved among all the parties that could have taken part of the incident. This means the liability of the two ship owners, the crane operator, the port terminal, the cargo interest, everybody who were involved. And these investigations will be relevant to those who suffered damages, material damages or losses. The claimants, to have a successful claim, will need to be able to demonstrate fault of the other party. As we all know, collision liability regime is mainly fault-based. Civil liability investigations usually begin by investigations which are carried out by the parties itself, usually on a friendly manner and voluntarily. But if they are not able to reach on an agreement, for example, in respect of the extension of the damages occurred or in the angle of collision, the parties are entitled to request judicially the production of preventive measures to secure evidence. And if their conflicts or disputes are not settled, a judicial proceeding will also be pursued which in this case in Argentina, these kind of proceedings are heard exclusively by the federal courts of civil and commercial matters, which are located in Buenos Aires, who have exclusive jurisdictions. So 3 different proceedings, 3 different forums, 3 different authorities, and 3 different kinds of evidence that have to be considered and taken into account when defining the defense strategy of our client to duly preserve their interests.
So that's a lot of work. Thanks for those inputs, Maria. Irrespective of this dramatic scenario, I'm comfortable to see that SNIPit3 connects us with experts from around the globe who are more than capable to assist in emergency situations. Before we conclude this conference, we still have some time left, and let me just fire away some brief questions that were presented by our audience in the Q&A, which I hope we can quickly cover. The first one is about security. What would you expect claims for security in your jurisdiction? Perhaps some of you could comment real quick on that.
We can expect in Malaysia for a receiver appointed by the Director of Marine under the Merchant Shipping Ordinance of 1952 to require financial security under or from the vessel's owners for the repairs of the collapsed crane, as well as ensure that the vessel's owners will salvage the wreck since it is sunken and grounded. In Singapore, though, the receiver can take possession of the ship by carrying out the wreck removal itself, then selling it with the cargo to reimburse itself. Any surplus proceeds will be held in trust for the owners. The other vessel's owners can also arrest the vessel for security, as collision claims in both Singapore and Malaysia enjoy the status of a maritime lien, which operates as an encumbrance or a security interest on the vessel from the moment the cause of action arose. Such a maritime lien is enforceable by way of an action in rem, and salvors will also have a right to arrest the vessel for a salvage claim.
Oh, thank you, Fuzet. Thank you for stepping in. Maria, anything to add about your jurisdiction in Argentina?
Definitely, yes. The party will be very interesting in obtaining letter of undertakings of the P&I club of the vessels involved or their insurers. The bargaining power to obtain it is very strong because either collision claims could be considered maritime liens, which entitle the parties to request the arrest of the vessel, or there is a specific provision which makes it very easy, and if a collision took place, just by presenting the statement prepared by the master when reporting the incident at the coastal authority is enough to get the arrest order of the vessel. So the bargaining power is very strong, and usually P&I clubs issue the letters of undertaking to secure the potential liabilities that could arise in this case. And in respect of the damages caused to port terminals facilities, the Maritime Authority is also entitled to detain the vessel until the vessel stipulations provides personal bond to secure the potential damages and fines that could arise within the administrative proceedings. So again, they have very strong power to request and obtain the securities, and the agents in these cases will often seek for counter security from the vessel P&I clubs to also be secure that their personal liability is granted.
Maria, thanks for covering that one as well. I did not forget about you, Tunji, but I have another question here in the chat that I would like to address with you if you can start. This one is about limitation, and I would like to invite you to comment on whether there would be any potential limitation regime available to the owner in your jurisdiction.
Yes, that would be the case. Our primary legislation in relation to commercial shipping is called the Merchant Shipping Act of 2007. He had very extensive provisions on limitation of liability in relation to maritime claims. But I think it's important to first highlight that the damages that are recoverable in respect of collision cases, the idea is to place the claimant in the same financial position as he would have been had the collision not occurred. And so the way the courts interpret this to mean is that he can only recover direct damages arising from the collision. Okay. Also, it's important to also highlight that oil pollution and nuclear damage are not subject to the limitation regime. And so if there's pollution arising from the collision incident, then clearly you can't limit your liability. There's also an exception if it's very clear that the act or omission was with the intent to cause damage, or it was reckless, or you can essentially assert that, he ought to have known that this kind of loss, would arise from his actions or omissions. In that scenario, he will also not be able to limit liability. But then now speaking as to the liability limit, it's denominated in units of account, which you typically find in the laws of many other countries. And this is in accordance with the special drawing rights as defined in the International Monetary Fund. So in the absence of any agreement by the parties, it would be converted into the local currency, the Nigerian naira, and the value of what that threshold would be based on the limitation fund or the date that the payment is made or security is given. So that's a brief overview of the limitation regime in relation to maritime claims for this scenario.
So thank you, Tunji, for bringing these interesting insights. And before I provoke Maria with one final question, let me just go back to Fuzet real quick to confirm if there's a limitation regime available in Singapore or Malaysia in that respect, Fuzet?
Yes, Singapore and Malaysia both are parties to the 76 Convention and the 96 Protocol, but Singapore has prescribed a higher units of account per ton of the vessel. However, if the court finds, though, that the loss resulted from the master's decision to oppose the pilot's advice to abort the maneuver, and that decision is his personal act or omission committed with the intent to cause such loss, or recklessly and with knowledge that such loss would probably result, then the vessel's owner will not be entitled to limit its liability.
And Maria, any limitation regime available in Argentina?
Yes, Argentina is not a party to any of the international conventions on global limitation for maritime claims, but Argentina has its own specific provisions in their navigation law. Ship owners, disponent owners, and register owners can limit by setting up limitation fund in cash at courts based on the value of the vessel, plus the credits and freights accrued during the last voyage. And be careful, because if the value of the vessel at the end of the voyage is zero, the limitation could be zero. And there is an additional provision which says that if the limitation fund is not enough to compensate claimants for death or personal injury, there is a supplementary fund based on a calculation done from the tonnage of the vessel. And also the registered owner has the possibility to limit by making abandonment of the vessel in favor of the creditors, putting at the disposal of the claimants the title of ownership of the vessel, and they will collect their claims from the produce from the price of the judicial sale of the vessel.
Oh, thank you, Maria. And please bear with me a little bit more, as we still have time for a short final question, and this is an important one. Imagine it was the club who contacted you in the first place to assist in such a casualty. This is something that the club would certainly be interested in knowing about your jurisdiction. Is there any risk of direct actions against the P&I club in your country?
In Argentina, in principle, the pay-to-be-paid rule is respected. Nevertheless, and there is no direct action against the P&I club per se. Nevertheless, there has been a plenary decision given by the Court of Appeals of Civil and Commercial Federal Matters in plenary, where it was resolved that in cases where the ship owner is in bankruptcy or similar situations, there could be direct action against the P&I club directly, only in those scenarios. The reasoning behind the decision was that the cost of the P&I insurance was included in freight, so it was not fair to preclude recovery because the owner was not able to pay to activate the cover under the pay-to-be-paid rule.
And Fuzet, any final words from you before we close this conference on the potential direct actions in your jurisdiction?
Sure. Here, there is a risk of direct action against the vessel's P&I club because for oil pollution damage, both Singapore and Malaysia are signatories to the CLC, or the International Convention on Civil Liability for Oil Pollution Damage 92, which provides that persons who suffer from pollution damage may claim directly from the vessel's owner, insurers. This saves a claimant having to track and arrest or attach an insured vessel when they wish to enforce a claim under the relevant convention as if it were the ship owner. And apart from that, direct action against a P&I club is usually a last resort, as a claim is usually first brought against the vessel owner, who then claims against their P&I club for their liability. A final judgment has been delivered in the proceedings. All the parties have reached a settlement, although we do need to look at the specific wording of the choice of law or jurisdiction clause in the LOU.
Well, thank you, everyone. I know there is too much to say on such a relevant topic, and the idea behind this SNIPit3 live conference is just to give our viewers a glimpse on how the matter can be treated in the different jurisdictions. For the additional questions that remained unanswered, feel free to address those directly to our speakers by email. And on behalf of SNIPit3 and our audience, I would like to thank our speakers of the day, Fuzet, Tunji, and Maria Belen, being confident to say that any client will be very well represented by you in your respective jurisdictions, no matter how horrible the case scenario can be. To our audience, many thanks for watching and for suggesting such a relevant topic. Now, back to you, Ansam.
Thank you very much to all of you and to the participants. I would like to thank our platinum sponsor, the law firm Kincaid, Mendes, Vianna, Advogados, and our gold sponsor, the law firm ITL Legal Consultants, MB, Espineira, and Lawyers. And thank you, everyone. We can close the conference. You can reach out to us on LinkedIn and everything, on social media, YouTube, Spotify, and see you at the next SNIPit3 live conferences, and follow us for episodes on the podcast. Thank you, everyone.